Welcome to our channel. Today I will be talking about the legal aspects of setting up a new company. Among other things, I will be talking about the choice among S corporation, C corporation, and limited liability company as the legal form of your new business legal entity. Again, a little bit about ourselves. We are a small business law firm in New York and California. We practice corporate law, intellectual property law, and business dispute resolutions. I am a New York lawyer and a corporate lawyer, and I concentrate my practices on corporate governance matters, mergers, acquisitions, and commercial loans, joint ventures, and other business matters. First, let me explain the concept of limited liability. Conceptually, the law, at least in the Western legal tradition nowadays, considers an economic entity, whether it's a corporation or limited liability company or other type of business legal entities, as separate legal person. And therefore, its assets, liabilities, and affairs are separate from those of its equity owners or creditors. Practically, what it means is that if the economic entity incurs any kind of legal liability, being general debts or judgments, things of such nature, generally its equity holders' personal assets are shared from such liabilities. What does that mean? That means if you borrow money from a bank, unless you provide personal guarantees to the bank, or the business gets hit by a lawsuit, by a judgment, you as the shareholder, your personal assets, your houses, your home, your cars are shared from that kind of liabilities, usually. The above is only true only if the parties, including the economic entity itself, observe the proper formalities of establishing and maintaining a business legal entity, and are not using the corporate entity as conduit for illegal activities. So, corporation versus limited liability company, right? So there are C corporation, S corporation, and limited liability companies, and other types of business legal entities. As a matter of business entity law, C corporations and S corporations are both corporations, and they are essentially different tax arrangements. And limited liability companies is another type of business legal entity as far as business legal entity laws are concerned. So there are pros and cons of each choice, and I will go over them briefly. For C corporation, the disadvantage is the double taxation if it's taxed as corporation. The income of the corporation is taxed at the corporate level, the profit of the corporation. And then if you distribute any profit to the shareholders in the form of dividend, the shareholders will have to pay dividend tax again. The advantage of a corporation is the concept of limited liability is much better practiced here than in the case of limited liability company, which I've soon explained. And the case law regarding corporations are much better developed. So you will face less legal uncertainty if there are disputes such as shareholder disputes. And it's much easier to go public. Equity holders could be an individual or another entity. And the limited liability company is kind of flip side of that to some extent. There's no double taxation if it is taxed as a pass-through entity or partnership. The cost of setting it is somewhat lower, and profits could be distributed among shareholders, among members, they call it, but not exactly based upon equity percentage holding. It gives you a little bit more flexibility. The disadvantage is that if it's taxed as partnership, then the partners, each of them, will be liable for the tax of the entire venture, and by implication, the tax that should otherwise be payable by other members of the limited liability company. And case law here is also somewhat limited and giving rise to a little bit more legal uncertainty. Usually, it's hard for you to design a stock option plan there, but you can have some phantom interest, profit interest for limited liability companies. And incomes, even before they were distributed, may be taxed as they are deemed to have been earned by each of the members. And SCorporation, it could be taxed as a pass-through entity, and so there's no double layer taxation. And it could take advantage of the better developed body of case law for corporations. However, shareholders of SCorporation needs to be natural person, meaning human beings, not another entity, let alone institutional investors. And each of the natural person has to be a U.S. tax resident. So let me work through the step to set up a corporation. You need to choose which state to incorporate. There's no federal corporate law. A lot of corporations choose to be incorporated in Delaware, especially those that has ambitions to go public. And that is because the case law there is much better developed. And how do you set it up? Initially, you file a certificate of incorporation. For that, you need somebody who to act as your incorporator. And you need to appoint a registered agent, which is an agent that will receive a service process on behalf of the corporation if the corporation is sued, meaning to receive the complaint, the legal paperwork, if the corporation is sued. And you may have other optional provisions, but you don't need really say much other than how many shares are authorized to be issued by the corporation. And then the incorporators will adopt the bylaws of the corporation. The bylaws do not really set forth the substantive rights or obligations of the shareholders. It really focuses on the procedural matters, like how do you call for shareholder meetings? How do you call for board of director meetings? And what kind of offices the corporation needs to have, such as the office of the CEO, the president, the secretary, the treasurer. And then the incorporator will appoint the board of directors for a corporation, and then it essentially resigns. So the board of the corporation, the board of directors, essentially being a governing body of the corporation, now takes over the governance of the corporation. The first order of its business is to confirm whatever the incorporator has done. Not much is except for the filing of certificate of incorporation, and occasionally the adoption of the bylaws for corporation. And sometimes the board could adopt the bylaws directly. And you notice so far there are no shareholders of the corporation, right? So the board of directors need to authorize the issuance of shares. And then the opening of bank accounts and some other kind of contracts of corporation, for example, the engagement of the registered agent and counsel. And the board of directors will also need to appoint officers who actually runs the daily operation of the company. And there are other things you need to do. If you have more than one shareholder, you better have a shareholder agreement setting forth the rights and obligations among the shareholders relative to the operation and governance of the corporation. You need to get the employer identification number, which nowadays will take you about 2 minutes. And if you're a Delaware corporation that needs to do business in other states, which may be where your principal office is, for example, in the state of New Jersey or New York or elsewhere, then you need to obtain the foreign qualification as a Delaware corporation to do business there in the state of New York, New Jersey, or Washington, or elsewhere. And then you need to get industry and specific permits or license. The steps it takes for a corporation are the foregoing. Now, after you set up the corporation, you need to follow the formalities to retain the benefit of limited liability. You need to keep minutes of all meetings of shareholders and all board meetings. You need to maintain stock ledger and shareholder list. You need to conduct meetings of shareholders at least once a year and carry out actions by written consent to elect board of directors by the shareholders, and to rectify appointment accountants and other professional advisors. You need to conduct special meetings of shareholders as required by the corporation's own organizational documents or the law. And one thing that a lot of people need to pay attention, close attention, especially small business owners, is that you should not commingle the funds or assets of the corporation and the assets and funds of the shareholders. The law gives you the benefit of limited liability based upon assumption that you can practically identify what are the assets of the corporation and what are the assets of the individual shareholders. If you practically commingle them, the law essentially will give up. And there are other substantive decisions that you need to make. And if you have more than one shareholders, you need to negotiate among all of you and document the understanding that you have reached with respect to issues. For example, what should be contributed to the company, who should contribute intellectual property, who should contribute money, who should contribute services, to operate the business and manage the affairs of the corporation. And how much equity interest do you get, and when do you get them, particularly for founders who are supposed to deliver service to the corporation? You usually do not want to give them a lot of equity interest in the corporation upfront before the services are actually delivered. And who will be sitting on the board of the corporation? Remember, the board gets to make a lot of important decisions for the corporation unless the law requires such decisions to be approved by the shareholders. And what could the board do? Again, in the absence of any kind of clear contractual arrangements, quite a lot. And what decisions must be made by the shareholders other than those that have been clearly spelled out by the law? It can be very, intense and detailed negotiation among the founders. And who is going to hold what office and receive what kind of compensation? That's related to options and how the shares, other type of restrict equity interest should be vested. And you may also want to, draft a comprehensive employment agreement for the individual officers of the corporation. And when and how can you kick out a founder, and what will happen to his or her shares in the corporation? Are you required to buy him or her out? Or do you only have the option but not obligation to buy him or her out? And at what price? So those are just a few critical things that you need to figure out and document beforehand. Otherwise, once you have any kind of fallout, you may have to hire expensive litigators. And this is today's topic. Thank you.